Yeah, so discovery is just that. Each side of a lawsuit gets to discover what the other side knows.
Discovery is a broad term, and what it deals with is ability for both sides to figure out what each other's case is. In our system, we don't want to have a trial by surprise. Our system favors both sides knowing what witnesses do you have, what exhibits do you have, what's the testimony going to be. They may not know your exact strategy, but they know generally what you're going to be able to present in trial.
They have the right to ask us questions about our claims and proof of those claims. They have the right to verify your claims with a medical authorization. So it's not, a lot of people think there's a lot of gotcha moments in court. There's not a whole lot of surprises.
Discovery starts out usually with written discovery, and that's where you're answering questions under oath, just like you would in court, but we're writing it down and submitting it to the other lawyer.
It means that the other side has gotten the lawsuit, they've acknowledged that the lawsuit exists, and they're going to have to answer some questions for us in writing. And you're going to have to answer some questions from them. And we're going to bring you in and walk you through that. You're going to meet with Nick and his assistant, and we're going to prepare you how to answer these questions.
It's important in those meetings that you're as forthcoming and honest with me as possible, especially when it comes to prior injuries, prior accidents, anything like that. If we leave those things out, the insurance company and their attorneys can very easily use that against you. We don't want to give them that opportunity. I want to know about everything, and that way I can decide what needs to be told to the other side or not, and I also know what to look out for in our case. And so when we're answering those questions, honesty is the best policy. Can't tell me too much, and I think that's the best policy, and that's what I tell all my clients.